Hey everybody, Harry here to talk about Jeff Clark's hearing in support of his motion to remove his case from Fulton County to federal court. Let me start with the bottom line. Doesn't look very good for old Mr. Clark. And in fact, I think Mr. Clark doesn't think it looks very good for Mr. Clark. He did not even show up to the hearing. Why wouldn't he show up to the hearing? Almost certainly because he doesn't want to be cross-examined. It's his burden to show he merits removal. And remember, based on this, Mark Meadows not just showed up, but testified. And besides losing the motion, he got beat up pretty good on cross-examination, did Meadows. Clark wants to avoid that fate, even though Clark just testified in his bar disciplinary hearing in California recently. All right, but to me, and I thought so going in, and I think most observers going out thought it didn't seem very persuasive. Okay, so first, the evidence. Clark wanted to proffer his own statement, but he didn't show up. So the judge can't consider it without his ability to be cross-examined. He was trying basically to get away with stuff. And he also submitted a declaration from former AG, 91-year-old Ed Meese, who himself has had a pretty checkered history, but he was the head of the Justice Department, and he wanted to say something like, hey, it's okay what Clark did because you can always give an opinion to the president when he asks for it. And it's also okay, even though he was officially just the in charge of the Environmental and Natural Resource Division, the president can kind of move you around to different areas and ask. And remember here, the president either wanted to or maybe for a minute and a half did move Clark to the position of acting attorney general. And so that's all okay. Meese, the state said, don't even listen to Meese. He's not here to be cross-examined. And the judge, the federal judge, Judge Jones, who had denied Meadows' petition, made it seem like he'll consider some of what Meese has to say, kind of out of respect. I don't think it would change very much. The big problem for the Meese opinion and what Clark wants to say is not so much, even though this is something that the DA argued, that Clark was in the environmental division and his official responsibilities didn't include this. It's really that what he did and what he's charged with in the indictment, say, unlike Meadows, who has a whole range of activities where he could at least argue, I was acting like a chief of staff and doing my general job. What Clark did was write this letter that said the Department of, and to send to Georgia folks, the Department of Justice has determined there's been fraud and irregularities. And that was to give an opening for Trump to run with it and to get the Georgia to look at it closely and stall the whole proceedings. The big problem with that letter, total lies. The department had not determined it. In fact, there was nothing to determine. And that's the real problem. If Jones undertakes the kind of analysis that he did with Meadows, it's very far afield from Clark's normal job description to be A, mucking around and meddling in state elections, but B, sending out what everyone knows, including his leadership above him in the Department of Justice, just lies on behalf of DOJ. That really would not seem to be anywhere near the overall job description. And the idea that it is true, let's say you can even credit it, that he was acting in his civil division duties. The Fulton County DA, for their part, had a witness who's the guy who succeeded Clark as head of the civil division to explain why this is nothing like under the normal responsibilities of a head of the civil division. That to me is all secondary. For one, there's some argument that Trump could make him whatever he wants him to be. But the bigger point is lying about the election, trying to badger state authorities into changing things around and taking away the rightful recipient of the electoral votes. That just doesn't fit anywhere in the job description. I think on that, he should fail to have removal, because remember what you need, both you're a federal official, but you're acting within the scope of your duties. You know, Clark, he doesn't show up. He didn't even know that he had to waive his appearance, and it wouldn't have been an official hearing, and the judge stopped everything and said, we better get this thing in from him right away. I think he's planning, basically, he's assumed he's going to lose this, maybe hopes he'll have some opening on appeal to the way Mark Meadows is now doing. But basically, it's a pretty tepid effort. And his own statement doesn't come in. The DA has things to say, and the burden goes to Clark, and that was something that the judge made a big point of before in the Meadows motion. So this kind of almost half-hearted, you would say, effort. Not exactly sure why he's doing it, unless he thinks he's got some good cards to play on appeal, but it doesn't seem well designed to win the hearing in front of Judge Jones. The hearing ended. Jones did not rule, but he's indicated he will rule soon. And given the way things have been going, you can expect that, and can expect the 11th Circuit to take up Clark's appeal in short order. And for my money, for what it's worth, I expect them both to say, Jeff Clark, no removal, back to state court with you to stand the charges that you've been accused of, basically the RICO conspiracy and this false statement based on a letter that was just a lie. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.